How to stop wage garnishment immediately. IRS, student loans, and creditor deductions. I'm Sean DeVries. Today we're talking about wage garnishment. If you've received a notice from the IRS, your student loan servicer, or creditor, it can feel overwhelming. You might be worried about losing income, keeping up with bills, or protecting your family, and that's completely normal. The good news is you're not helpless. There are steps you can take to stop garnishment, reduce its impact, and protect your financial future. In this video, I'll break down everything you need to know about wage garnishment. We'll cover what it is, how it starts, what your rights are, and, most importantly, how to stop it. I'll also explain how bankruptcy can offer relief and why it may be the fastest way to regain control if garnishment has already begun. Wage garnishment happens when a court or government agency orders your employer to take money directly from your paycheck to pay a debt. Common types of garnishment come from the IRS, federal student loans, and private creditors. The process usually starts when a creditor obtains a judgment against you or when a government agency decides to collect a debt. Once they do, they can continue to contact your employer and request that a portion of your wages be withheld. Most people first learn about a garnishment through a notice from their employer or a letter in the mail. That moment can feel shocking, but understanding what happens next can make it less stressful and give you a sense of control. The first thing you need to know is that garnishment doesn't happen overnight. There's usually a series of steps before money comes out of your paycheck. For IRS garnishments, you'll receive a notice called a final notice of intent to levy, along with your rights to request a hearing. Student loan garnishments often follow multiple missed payments and notices, particularly for federal loans in default. Creditors generally must sue you first and get a court judgment before the garnishment begins. Timing matters. Acting early can prevent garnishment entirely or reduce the amount taken from your paycheck. Many people make the mistake of ignoring garnishment notices. They may feel anxious or hope the problem goes away. Ignoring a notice usually makes things worse. Let me repeat that. Ignoring a notice usually makes things worse. Once garnishment begins, options become more limited. Though action is still possible, filing an answer to a creditor lawsuit, requesting a hearing with the IRS, or negotiating with your student loan servicer can all protect your income. Acting promptly, even after garnishment has started, you can sometimes stop future wage deductions or reduce the amount withheld. Let's start with IRS garnishments. The IRS begins the process by sending multiple notices. They include letters detailing the amount owed, penalties, and interest. The IRS must give you at least 30 days to respond before they start garnishing wages. This period is your opportunity to act. You can stop garnishment through installment agreements, offers in compromise, or by demonstrating financial hardship. Even if garnishment has started, it's often possible to negotiate a resolution, though acting earlier is always better. An installment agreement allows you to pay your debt over time, propose a monthly payment based on what you can afford, and the IRS evaluates your finances. If accepted, wage garnishments may be stopped immediately, and you'll always avoid further penalties. Offers in compromise. Offers in compromise allow you to settle the debt for less than the full amount owed. These are not available to everyone, and the creditor needs to essentially approve it, but they can be an effective way to resolve IRS debt quickly. In hardship cases, you may qualify for currently not collectible status, which pauses garnishment until your financial situation improves. Student loan garnishments operate differently, particularly for federal loans. If you default on a federal student loan, the Department of Education can garnish up to 15% of your disposable income without going to court. This can happen automatically. Once your account is in default, it can start. Private student loans usually require a judgment first, but the end result is similar. A portion of your paycheck is taken to repay that debt. Options to stop federal student loan garnishment include rehabilitation programs, repayment plans, and consolidation. Loan rehabilitation involves making a series of on-time payments which can remove the default status and stop garnishment. Repayment plans adjust your monthly payment based on income, reducing or eliminating garnishment. Consolidation allows you to combine multiple federal loans into a new loan with a manageable payment schedule. Each program has specific rules and deadlines, so acting promptly is essential. Creditors must follow legal procedures before garnishing wages. Typically, they file a lawsuit and obtain a court judgment. Once they have a judgment, they request a garnishment order from the court. Employers are legally obligated to comply. Federal law limits garnishment amounts to 25% of disposable income or the amount exceeding 30 times the federal minimum wage, whichever is less. Understanding this helps you anticipate the financial impact and plan accordingly. In Florida, it's important to note if you're supporting a minor, you may be able to have the garnishment stopped because of your head of household income. But most of all, stopping garnishment requires knowing your rights. For IRS garnishment, you can request a collection due process hearing. For federal student loans, you can ask for a review of your financial situation. For creditors, filing an answer or motion to challenge the garnishment may prevent or reduce the amount taken. Each step has strict deadlines, and missing a deadline often eliminates your chance to challenge the garnishment. Acting early is critical. Exemptions exist. Some income cannot be garnished. Social Security benefits, disability payments, veteran benefits, and certain retirement accounts are usually protected. Knowing which income is safe helps you plan and sometimes provides options to pay debts without losing essential income. This knowledge also gives leverage in negotiations with creditors or the IRS. Negotiation is a powerful tool. That's how I spend most of my time, negotiating. Many creditors are willing to work with you if contacted before garnishment begins. You can propose a payment plan, offer a lump sum settlement, or request hardship relief. For student loans, entering repayment programs or consolidating loans may stop the garnishment entirely. With the IRS, installment agreements or offers in compromise can halt garnishment while you pay off the debt over time. Acting before garnishment starts increases the likelihood of a favorable outcome. Even if garnishment has already begun, bankruptcy can provide relief. A filing Chapter 7 can discharge many debts entirely, stopping garnishment on qualifying debts. It's important to note that this does not typically include IRS debt or student loans, but there are options to help you stop that as well. A Chapter 13 allows you to restructure debts under a repayment plan, often reducing or eliminating garnishment, while you make manageable monthly payments. Bankruptcy is a legal tool that can reset your financial situation, protect your income, and give you breathing room to rebuild. Chapter 7 bankruptcy eliminates unsecured debts, including credit cards, medical bills, and some private loans. Once filed, the court issues an automatic stay, immediately halting wage garnishments, creditor calls, and collection actions. For families living paycheck to paycheck, this creates space to reorganize finances. Chapter 13 focuses on restructuring debts through a court-approved plan, allowing you to keep assets, catch up on missed payments, and stop garnishments, while making one monthly payment. Bankruptcy is more than a legal process. It's a financial reset. It's a tool. It may impact your credit temporarily, but it prevents further garnishment and provides a structured path to repay. Filing with an experienced attorney ensures eligibility, timing, and exemptions are properly managed. An attorney evaluates your debts, determines the best chapter to file, and guides you through the process efficiently. Acting quickly matters. Knowing your rights and options reduce the risk of losing income unnecessarily. Responding to notices, requesting hearings, negotiating settlements, and considering bankruptcy all put that control back in your hands. Doing nothing is the worst choice. It leads to continued garnishment, growing interest, and stress. If you're facing wage garnishment, contact my office for a consultation. We'll review your situation, explain your options, and outline a strategy to stop the garnishment and protect your income. We handle IRS, student loan, and creditor garnishments and guide clients through bankruptcy when necessary. You don't have to face this alone. In upcoming videos, we'll break down each type of garnishment step by step. We'll include templates for responses, negotiation scripts, and strategies for Chapter 7 or Chapter 13 filings. Subscribing ensures you get the next video as soon as it's released. Check the links below for free guides, worksheets, and resources that help you take immediate action. The key to stopping garnishment is understanding the process, knowing your rights, and acting without delay. Now let's dive deeper into IRS garnishments. The IRS has a series of notices that lead up to wage garnishment. The first is usually a notice of intent to levy, and this explains the total debt, which includes interest and penalties. The notice also informs you of your right to a hearing. At this point, garnishment has not started. Filing a hearing request pauses the process during the hearing. You can negotiate an installment agreement, request an offer in compromise, or show financial hardship. Acting at this stage can prevent garnishment entirely. Installment agreements are common. The IRS evaluates your income, expenses, and your ability to pay. You propose a monthly payment, and if accepted, your garnishment stops immediately. Offers in compromise allow you to settle for less than the full debt. Qualifications include proving inability to pay the full amount and demonstrating good faith efforts. If approved, the IRS stops collection and garnishment. Financial hardship can also prevent garnishment temporarily. Student loans have a unique process. Federal student loans can garnish up to 15% of disposable income without court involvement. Once in default, notices are sent to the borrower detailing the default status and garnishment. So understanding your options and acting quickly is critical. With private student loans, this is different. Typically, private lenders must sue and obtain a court judgment before garnishment can begin. This process is slower than the federal garnishment, but still results in a wage deduction once a judgment is entered. Federal law limits the amount that can be garnished, which gives some predictability in planning, but knowing these limits allow you to budget and explore options to challenge or reduce the garnishment. For private creditors, the process begins with a lawsuit. Once a judgment is granted, the creditor requests a garnishment order from the court, and employers are legally required to comply with these garnishment orders. Federal law sets limits on how much can be garnished, and that's usually 25% of disposable income or the amount exceeding 30 times the federal minimum wage, whichever is lower. Understanding these limits help you anticipate the impact on your paycheck and plan expenses. Challenging garnishment for private creditors often involves filing an answer to the lawsuit or requesting a hearing. You can argue exemptions, financial hardship, or procedural errors. Courts generally review these claims seriously. Filing a timely response preserves your rights. Missing the deadline allows garnishment to continue, often with little opportunity to reverse it. Exemptions are an essential part of garnishment law. Certain income types are protected and cannot be garnished. Social Security benefits, disability payments, veterans benefits, and retirement accounts are generally safe. Knowing which income is exempt can help you preserve essential funds while addressing garnishment on other sources of income. This knowledge also gives leverage when negotiating with creditors or government agencies. Negotiation is a powerful tool, and timing matters. Many creditors are willing to work with you if contacted before garnishment or judgment begins. You can propose a payment plan, offer a lump sum, or request hardship relief. Even if garnishment has started, some creditors will pause deductions while negotiations occur. Student loan servicers and the IRS often have similar programs, but most importantly, acting early increases the likelihood of a favorable outcome and may allow you to stop the garnishment entirely. Again, bankruptcy is another option to stop garnishment immediately. Filing bankruptcy triggers an automatic stay, which immediately halts wage garnishment, creditor calls, and other collection actions. Chapter 7 bankruptcy discharges unsecured debts such as credit cards, medical bills, and some private loans. Chapter 13 bankruptcy allows you to restructure debts under a repayment plan, often stopping garnishment while you make one manageable monthly payment. Chapter 7 bankruptcy is a fast and effective way to stop the garnishment once the petition is filed. If you are in Florida and wage garnishment is affecting your income, it is crucial to speak with an attorney experienced in these matters. Legal guidance ensures accurate filings, protection of income, and strategies tailored to your situation. You do not have to face garnishments alone. Contact our office today to schedule a consultation. Let's review your options and take immediate steps to stop wage garnishment and protect your paycheck. Call us now or visit our website to get started. I'm Attorney Sean. Tune in next time. Take care.